Hello, good morning everybody, ladies and gentlemen. First of all, thank you very much for the invitation. I'm really honored being here and having a chance to give a speech on some issues connected to Polish legal education system. And once again, I would like to express my words of gratitude to the authorities of the law faculty of the Vytautas Magnus University in Kaunas for giving me the chance to be here and to teach here. It's a brilliant experience for me, and I'm really grateful for that. So I'm very sorry. To the point. I'm going to try to give you an overall general overview on the Polish legal education system, because when I first got the invitation and when I saw what the organizers want me to talk about, I realized that it would require me to in a way to evaluate myself and my colleagues and the job we are doing in Poland, and I would not really do that. Too much criticism would be required, I suppose. But what I'm going to do is to focus on some more general remarks, and in this way I'm going to leave a space for the further discussion, which I can see already is going to be very interesting for the further discussion, for the questions, for the conclusions, and for possible comparisons between Lithuanian and Polish legal education system. What I'm going to focus on are two stages of Polish legal education system. First of all, the legal education on the university level. So the legal education at faculties of law in Poland. And the second stage is this so-called practical course of study in form of something that we call in Poland apprenticeships. It's called aplikacja. This is something that is meant for master graduates in law in order to get a license to be active in the legal profession. Because finishing master studies in Poland, master studies in law, is not equal to having a license to be an active advocate, legal advisor, etc. You have to finish another course of study. I'll get back to that later on. But let me start with this stage of education on the university level. This is something that we still call education rather theory-oriented. This is strictly connected with the fact that in most cases law is taught in Poland in the form of a lecture. Only approximately one third of teaching hours should not be taught in the form of a lecture. And the lecture, according to its normal and typical definition, is more about telling something about theory, about legal regulations, and about taking notes by the students. Of course, depending on the professor, and in most cases the lectures are led by the leading professor of the particular department. Depending on the person, of the teacher, of the lecturer, those lectures might get a bit more interactive. Some of the professors are trying to encourage the students to be more active, to interact, to ask questions, but anyway, the lecture remains a lecture, and this is the most typical form of law teaching in Poland. And to balance it in a way, we have something that we call the direct translation would be exercises. We call it ćwiczenia, exercises, classes. Classes as a form of education, as a form of teaching, during which students should be provided not only with the theoretical knowledge, but their attention should be also put on more practical aspects of the problems and issues that were subject to the lecture. So they are working in groups, in small groups, they are doing their individual work, they are working with legal acts, legal texts, judicial rulings and judicial decisions, just in order to to get to know how to understand those texts, what is the meaning of those texts, what are the consequences of particular regulations, and this is something that they should be provided with during the classes. This is something that, in our opinion, should balance a bit this theoretical sphere that is subject to the lecture. During the classes as such, of course, there is a chance to deepen the knowledge of the stuff subject to the lecture. They give a chance for further explanation of the things that were discussed during the lecture, but there are certain doubts about the fact whether really those classes they balance theoretical lectures in a proper way. Of course, the best idea to estimate that system is to ask students what do they think about it, how do they what are their opinions about this system combining lectures and classes. Are they satisfied with that or not? And there are some surveys about that. Recently, 2012, there was one quite interesting survey, and the results they showed that. And just let me read it. Over 85% of respondents believe that law schools prepare them very well with theoretical knowledge in different fields of law, and that is understandable, and that is quite obvious if we take into consideration the way the students are taught at law faculties. But over 70% of Polish law students believe that education they receive at law schools poorly prepares them to apply law in practice. I'm not saying that it was not the question if you are well prepared to be a practicing lawyer. The question was whether the education you receive prepares you to apply law in real life. And over 70% of Polish students say that this is achieved only poorly. Almost 45% of respondents say that legal studies prepared to pick up a legal job poorly or very poorly. This is the question about how good are you prepared for being a practicing lawyer. Almost 45%, they think, their opinion is that they are poorly prepared to that. As reasons for that state of play, the respondents indicate that, and this is almost 72%, that there is not enough practice-oriented courses during their studies. Secondly, they are indicating that there are too many theoretical courses. Over 21% of responders say so. And third thing is that this is the consequence of the so-called massive education. I'm not sure how does this problem look like here in Lithuania, but in Poland it is so that we are teaching more and more and more students. We are allowing and enrolling more and more students. So the education gets massive. And if in that case it is really possible to prepare properly somebody to be a lawyer, or at least to apply law, to use his knowledge in practice, this is a question, of course. One thing more, also quite surprising and maybe disappointing. Every fifth respondent believes that the lectures and classes, something that is meant to be more practice-oriented during the legal studies at the law faculty, they do not differ and are both theoretical. Classes do not fulfill their role according to the students' opinions. This is something that, in my opinion, this is a problem. This is a problem. And this is something that I would like to finish this overview on the legal education on the level of universities And now let me get to the problem of the further stage of study, so-called apprenticeships. Do I have still a few minutes? As I told you before, this is the system which requires graduates, master graduates in law, to fulfill, to finish another course of studies, which is called apprenticeships. Those are specially meant for advocates, legal advisors, public notaries, and for prosecutors and judges. And those apprenticeships are led by bar chambers, bar associations. They are responsible for the education on that stage. And in that context, I would like to mention one quite interesting reform that we are experiencing and undergoing these days, because previously those bar associations were exclusively, I would say, responsible for those apprenticeships. It also meant that they were those ones who were able to say who will be enrolled and who will be not. They had the right to say to whom, in fact, a certain profession will be opened. They were saying, for example, we are responsible for the education of the future lawyers. And since this is our responsibility, we have to have an influence, a huge influence, on the problem of admittance to those apprenticeships. Unfortunately, it all ended in the situation in which the access was free mostly to the members of families, for example, or to the friends, etc., etc. Others were left aside, no matter how good they were after finishing their master studies. That was the problem, and the reform began a few years ago, and they have changed the system of entrance exams to those apprenticeships. Now this is a central exam, and this is anonymous, so if you pass the exam, you have a chance, you have a right, you are enrolled as a member of an apprenticeship for advocates or for legal advisors. But together with this change, the capacity of those bar associations, regional bar chambers, did not, let's say, increase. So now they have to teach many, many more students who pass the exam, entrance exam, but they have no place for that. Because previously, for example, they were teaching 20 people a year. Now they have to teach 120 people a year, every year, because so many people pass the exam, entrance exams. Of course, I suppose that this is a transitional problem, that they will change their attitude, and they will get some more space for that, they will get some more people responsible for teaching, but this is something that shows that not always something that is based on very, very noble ideas works properly in practice. And one thing more, only finishing those apprenticeships gives you the right, gives you the license to be active as a lawyer, as an advocate, legal advisor, notary, etc. But taking into consideration all those remarks I have already discussed with you, there appears another question, and this is something that we are discussing recently in Poland quite intensively. This is a question about the quality of lawyers. I know and I'm aware of the fact that this is a quite sensitive problem, but still very important. But as such, maybe this one should be subject to the next ELSA conference. Thank you very much for your attention.